Hello and welcome to another edition of Coffee Talk with immigration attorney Brian D. Lerner. In this particular episode, we're going to be talking about various employment-based petitions and generally the procedures that are involved and a little bit of specifics on what it is that you're able to come in on in the U.S. and how it works in regards to procedure. Now, a lot of times people think that the only way that they're able to come into the United States is on a family-based petition, being, whether they're spouse or sibling or parent or son or daughter, and there are several different categories for family-based petitions. However, there's a whole nother world of immigration law that allows employers to petition and allows you to come in years and years earlier, depending on your education and depending on the qualifications. So basically, if you either have a family-based petition that's 10 to 15 years away or a lot of years away, but you also have, for example, a college degree, you might seriously want to look into the realm of employment-based petitions in order to try to come into the U.S. years earlier. Now, let me just give a brief overview. Now, the most popular employment-based preference would be referred to as EB3. That is the employment-based third preference. And generally, that is when a particular job requires at least 2 years experience or more, and/or when you have a college degree, okay? There's also a subcategory on EB3 for jobs that require less than 2 years experience. But either way, the way that it begins, the way an employment-based petition begins, at least in the EB3 category, would be through what's called the PERM, P-E-R-M. And PERM is what used to be referred to as labor certification, okay? The bottom line with PERM is that the whole process of getting the account, doing the advertisement, running through all the recruitment, doing everything you need to do, the bottom line is you're showing there's no available U.S. workers for the position. That's what it is. And so the PERM itself is all done electronically now, okay? There's no more filling out of the 9089 physically and sending it in, although technically you could, especially if you do not, get the electronic account. But with PERM, the way that you go about this is first the employer has to open up an account, a PERM account, and then create a sub-account for the attorney, okay, assuming you have an attorney. Primarily, this is because in the past there's been some fraud, there's been some allegations that the employer wasn't real, whatever it happens to be. In this particular case, that's how it goes. So you have to have the employer create the account first. And then another thing, as far as attorney's fees go, the employer has to pay the attorney's fees for a PERM, not the employee. There can be no reduction in salary, no payback, no reimbursement, nothing. And also for the advertising. So, that has dissuaded a lot of employers from going forward with the PERM, which may or may not have been the original purpose. But in any case, the PERM starts the process, and once the PERM is done, and let's just say that you've done all the advertising, because you have to show that there's whatever recruitment comes, whatever resumes come, they have to be properly interviewed and so forth. And let's say that you get an approved PERM. That does not mean that you magically get the green card right then. What that means then is that you have 180 days to file what's called the I-140 petition. And the I-140 petition, essentially, the purpose of that is to show that the employee, the future employee, qualifies for the position, okay? If the future employee qualifies for the position and the I-140 is approved, then you're 2/3 of the way there. Then the last third would be either an adjustment of status if you qualify inside the United States, or consulate processing if you're outside the United States and you need to come in as a lawful permanent resident. Now here's where the time takes. With an EB-3, and we're going to say skilled labor, that's when, again, you need either a college degree or 2 years experience. Generally now, depending what country you're from, that's about a 5-year wait, okay? And that may seem like forever, but again, if you're, for example, doing a sibling petition, from the Philippines, that's a 22-year wait, or various lawful permanent residence petitions, or married son or daughters of U.S. citizens. All of these are many years, and again, depending where you're from, India, Mexico, Philippines, it's even longer. So the wait for an EB-3 PERM petition is far less. So again, we're talking immigration here, so when we're talking 5 years, in other areas of law, that may be eternity, but in immigration, it's not so bad. So that's generally how the EB-3 will work. And if you have experience doing whatever it is you're doing, it's possible you could find an employer that will get you into that skilled category. You can move in as a manager, a supervisor, and so forth. Also, of course, if you have the degree and some experience, it could be done in regards to that. So there's different ways of getting a PERM on an EB-3 filed. Now, what other categories are there? Well, let's move up to EB-2. EB-2 is employment-based second preference, and there's different categories here, exceptional ability and so forth. But the one that's most popular for EB-2 is the advanced degree, okay? If you have a master's degree or higher, then you fall under the EB-2 category, assuming that the job requires it. Just to exaggerate, let's say you get a job as a cashier, but you're requiring a master's in electrical engineering. Well, obviously that won't work, okay? The job has to be indicative of that particular degree. So the procedure is more or less the same. I mean, the advertising on an advanced degree PERM is more complicated. You have to do a bit more and so forth. But when all's said and done, if you get the PERM approved on an EB-2 advanced degree and then do the I-140, again, the petition to show you qualify. And just as a side, let's say that you have the whole PERM advanced degree and everything approved, and then it turns out that you, the applicant, don't actually have your master's, or you didn't get it until 3 months after the PERM was filed. Well, the I-140 is going to be denied because you didn't have the qualifications for the advanced degree PERM at the time that you filed it. So assuming that, you don't fall into that trap, once the I-140 is approved, then again, the third step is you do adjustment of status or consulate processing. And the thing about the EB-2 is generally all over the world it's current. Okay, there are, for example, India has certain backlogs. They have a lot of people with master's degrees in India, and so again, it depends what country you're from, but for the most part, the EB-2s are current. So if you have a master's degree, that is a great way to come into the U.S. because it's just processing time. It's not waiting time for a visa to become current. So you do the advanced degree PERM, you do the I-140, you turn around, do the adjustment or the consulate processing. So then you say, well, what if you don't have a master's degree, but you still want to get under the EB-2? Well, that's still possible, but you have to show that you have either 5 years of progressive experience, which is equivalent to a master's degree, and then you can fall under the PERM. But again, progressive experience, there's different definitions of that. But for example, let's say you've been an accountant doing bookkeeping work for the, for the last 10 years. Well, if you've done the same kind of work for all those years, that's not really progressive experience, and you're not going to get the equivalent of a master's degree. but you can look at the work you've done. You can also get evaluations by professional organizations to show you have a master's degree, because that's what you want to do. Now, there's always the issue, though, of the prevailing wage. Obviously, if you're offered a job that just requires a bachelor's degree, it's going to be a certain amount. But if you require a job that involves a master's degree, the prevailing wage, or the amount the employer is required to pay you, is considerably higher. So if you're going to go forward and do the advanced degree PERM, make sure the employer has sufficient money in which to pay you from the time it's filed all the way until when you have the green card. And that, by the way, that's called the ability to pay issue. That's why a lot of these PERMs and advanced degree PERMs get denied, because even though everything went through, the employer can't prove that they make sufficient money. And sometimes they have a great accountant, so they have a loss, or they don't have a big net income, and that's fine for accounting purposes, but for immigration purposes it's not going to help. So you need to make sure on that before you go forward. So that generally would be the EB2 category. And again, there's some other areas of the EB2, such as national interest waiver, where you file it and you show it's in the national interest, that you don't have to go do actually a labor cert or a PERM, and there's different categories. But the next one would be called the EB1. And as you guessed it, as we're moving up the preference category, employment-based one is actually the most preferred one that the United States wants. So those basically are always current. I don't think I've ever seen an EB1 category from any country backlogged. And the EB1 does not even require a PERM. Okay, there's no PERM required. So with EB1, you jump over the PERM and you go right to the I-140 stage, and then, assuming it's approved, you do the adjustment and consular processing. So you're asking, what could qualify for an EB1 that the United States wants so much that they let you jump right over the PERM, where you don't even have to prove that there's available U.S. workers or not? Well, one would be what's called the multinational manager visa. Okay, the multinational manager visa, which I have other videos on that, but that's basically you own a business or have a business in a foreign country that's doing fairly well. You open up a branch office or sister corporation here in the U.S. It creates jobs, it creates income, and so forth. And assuming you meet all the qualifications, you as a business person can come on an EB1 multinational manager visa. Very nice visa for you, your spouse, your family. So if you, the key here is if you have a business in your home country, you want to look into the EB1 category. Also, EB1s are for extraordinary aliens. Okay, that's what it's called, extraordinary aliens. And it's those who have risen to the very top of their field. Well, you have to narrow it down. That's the secret here. Like, for example, if you're an engineer, okay, you don't just say you want an EB1 as an engineer, because there's 20 million engineers around, and it's going to be very difficult to prove you're on the top. So you narrow it down. Maybe you're an engineer of various aeronautical engineering systems, and then you narrow that down, and maybe it gets to the wing assembly of various space aeronautical engineering devices. You keep narrowing it down so that you then do become one of the top of that particular field. And if so, the U.S. wants people who are at the top of their field. They don't make them jump through the hoops, although, to be honest, to get an EB1 on this category is not easy. Usually the petitions I put through are about 3 or 4 inches thick and have a very hefty legal argument as to why. But it doesn't always have to be a technical area either. I mean, I once got an EB1 for a golf coach. So it all depends on how good you are and what field you're in, and of course how it's put together. So that basically is the rundown of various employment-based categories. There is another one, and the other one is we have to jump down. It's called the EB5. Okay, and the EB5 more or less is when you have $1 million to invest in your own business here in the U.S., or you invest in a regional center for $500,000. Either way, that's when you have a whole lot of money and you're going to invest in a business. So that would be the EB5. And then if you're keeping track of the numbers, you know I've gone over EB3, then EB2, then EB1, and then EB5. So you're saying, well, what's EB4? Well, EB4 is sort of a combination of, it could be, family related for VAWA, which is, battered spouses, but then also for EB4 you can have a special immigrant religious worker petition. So again, this is more or less an employment-based petition, but it's on a religious basis, and again, no backlogs with EB4s either. So if you happen to be in a religious capacity and have been paid the last couple of years, you come in on an EB4. So you can see there's all kinds of variations, categories, and so forth that you can come in on. And it's not just family-based, the whole world of employment-based immigration. So, if you'd like a consultation, give me a call, give me an email, however you want to do it, and I'll be happy to help. More on the coming video.